The 8,596th meeting of the Security Council is called to order. The provisional agenda for this meeting is the promotion and strengthening of the rule of law in the maintenance of international peace and security, international humanitarian law. The agenda is adopted. In accordance with Rule 39 of the Council's Provisional Rules of Procedure, I invite the following briefers to participate in the meeting. Mr. Miguel de Serpa Soares, Under-Secretary General for Legal Affairs and United Nations Legal Counsel. Mr. Peter Maurer, President of the International Committee of the Red Cross, and Ms. Annyssa Bellal, Geneva Academy of International Humanitarian Law and Human Rights. It is so decided. Mr. Maurer is joining via video conference from Geneva. The Security Council will now begin its consideration of item 2 of the agenda. I wish to draw the attention of the Council members to document S/2018/629, a letter dated 5th of August 2018 from the Permanent Representative of Poland to the United Nations addressed to the Secretary General, transmitting a concept paper on the item under consideration. I now give the floor to Mr. Miguel de Serpa Soares.
Thank you, Mr. President. I would like to thank the Security Council for inviting me to this meeting, and also a special greeting to my colleagues and friends from the ICRC. Just over 70 years ago, on the 11th of August 1949, a diplomatic conference convened in Geneva adopted the 4 Geneva Conventions, and on the following day, its final act was signed by the participating states. The 4 conventions entered into force around a year later on the 21st October 1950 and have been at the core of international humanitarian law ever since. The 4 Geneva Conventions were by no means completely novel at the time. The first 3 conventions found their origins in previous treaties and were revised versions of them. The 3 conventions are the first convention that deals with the wounded and sick in armed forces in the field, the second convention with wounded, sick, and shipwrecked members of armed forces at sea, and the third convention with prisoners of war. The fourth convention was, however, the first treaty that was specifically dedicated to the protection of civilian persons in time of war. Most of the provisions in these 4 conventions are applicable to international armed conflicts, in other words, armed conflicts between states. However, there is a provision in each of the 4 conventions that applies to non-international armed conflicts, which is Article 3, common to the Geneva Conventions. This provision contains basic rules on the humane treatment of persons taking no active part in hostilities, including members of the armed forces who have laid down their arms or who have been placed hors de combat by sickness, wounds, or detention, as well as civilians. The inclusion of Common Article 3 in the Geneva Conventions was a historic moment for humanity. It was the first instance in which non-international armed conflicts were regulated by a multilateral treaty. The significance is augmented by the fact that the Geneva Conventions are now universally adhered to. There is no doubt that Common Article 3 has become one of the most important provisions in the Geneva Conventions, not only because of its nature, which I have just mentioned, but also because it is perhaps the most frequently applied provision in contemporary armed conflicts, which are mostly non-international in character. Common Article 3 was subsequently developed and supplemented by Protocol 2, additional to the Geneva Conventions, and the number of customary rules have been recognized as being applicable to non-international armed conflicts. But Common Article 3 still occupies a special place in international humanitarian law. Now, the relevance of the Geneva Conventions to the work of the United Nations might not have been so obvious in the early years of the organization, as the Charter does not specifically refer to international humanitarian law. However, the United Nations was established in the aftermath of World War II, which saw violations of international humanitarian law on a massive scale. The Charter, in its preamble, contains a solemn declaration of a determination to save succeeding generations from the scourge of war, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, and in its Article 1st further provides that one of the purposes of the United Nations is to achieve international cooperation in solving international problems of a humanitarian character and in promoting and encouraging respect for human rights. In this regard, it is not surprising that international humanitarian law has become one of the most important areas of international law that guide the work of the organization today, including the Security Council. The role of the United Nations in situations of serious violations of international humanitarian law has also been specifically recognized in Article 89 of Protocol 1, additional to the Geneva Conventions, which requires that high contracting parts act jointly or individually in cooperation with the United Nations in situations of serious violations of the Geneva Conventions and of the Protocol. In practice, all competent principal organs of the United Nations have dealt with issues related to international humanitarian law in one way or another. As far as the Security Council is concerned, it has on several occasions recalled, I quote, its primary responsibility under the Charter of the United Nations for the maintenance of international peace and security, and in this context, the need to promote the rules, respect for the rules and principles of international humanitarian law, such as in Resolution 2474 of the 11th June this year. Now, with respect to the Geneva Conventions specifically, it was only in 1967 that the Council invoked those conventions for the first time in one of its resolutions, almost 20 years after their adoption. Since then, the Security Council has made express references to the Geneva Conventions or to specific provisions from them in its resolutions, but in a large majority of instances, the Council has invoked international humanitarian law generally or its customary rules rather than specific treaties or provisions from them. With respect to international humanitarian law generally, the Council has played a crucial role in ensuring respect for that law. Apart from the Council's frequent condemnation of violations of international humanitarian law and its call on the parties to the conflict to respect the obligations that it lays down, the Council has taken concrete measures such as establishing international criminal tribunals to prosecute war crimes as well as the crime of genocide and crimes against humanity, authorizing the establishment of commissions of inquiry to investigate alleged violations of international humanitarian law, mandating peacekeeping operations to protect civilians, particularly in the context of ongoing armed conflicts, including by the use of force, authorizing humanitarian agencies to carry out cross-border humanitarian assistance pursuant to a binding decision of the Council, requesting the Secretary General, his special representatives and envoys, peacekeeping operations, and special political missions to monitor potential violations of international humanitarian law in ongoing conflicts, requesting the Secretary General to report on certain thematic areas such as the protection of civilians in armed conflict, children in armed conflict, and the protection of medical and humanitarian personnel exclusively engaged in medical duties, and imposing sanctions on individuals and entities involved in violations of applicable international humanitarian law. The breadth of actions taken by the Security Council shows that the Council has great potential and flexibility for ensuring respect for international humanitarian law. While the United Nations has a role in ensuring respect for international humanitarian law by others, it is at the same time an entity to which international humanitarian law applies. And this is relevant to all United Nations personnel in armed conflict situations, but it's particularly relevant to United Nations peacekeeping operations deployed to armed conflict situations, some of which have increasingly been targeted by armed groups. The Geneva Conventions and other instruments of international humanitarian law do not contain specific provisions concerning the protection of United Nations peacekeepers. However, there is no doubt that they are protected by international humanitarian law in situations of armed conflict, that they are entitled to the humane treatment set out in Article 3, common to the Geneva Conventions, was specifically recognized most recently by the International Tribunal for the former Yugoslavia in the Karadzic case. The Rome Statute of the International Criminal Court further criminalized intentional attacks against peacekeepers as a war crime, as long as they are entitled to the protection given to civilians under the international law of armed conflict. The Convention on the Safety of United Nations and Associated Personnel of 1994 provides further protection to United Nations peacekeepers by prohibiting attacks against United Nations and associated personnel, and by requiring states parties to submit relevant cases to the competent authorities for the purpose of prosecution. However, as many host countries are not yet parties to the Convention, in practice, the application of the Convention in those countries has been made possible only by ad hoc arrangements, namely by including a specific provision in the relevant status of forces and status of mission agreements. In view of the fact that United Nations peacekeepers continue to be attacked, I appeal to the Council and Member States to further reflect upon ways to ensure that attacks against peacekeepers are properly investigated and, where appropriate, prosecuted. United Nations peacekeeping operations are not only protected by international humanitarian law, but are also bound by it in certain circumstances. And that this is the case is recognized in the organization's Status of Forces agreements and in the Secretary-General's Bulletin on the observance by United Nations forces of international humanitarian law. As far as MONUSCO in the Democratic Republic of the Congo is concerned, the Security Council has specifically mandated it to carry out targeted offensive operations, and I quote, in strict compliance with international law, including international humanitarian law, end of quote. In order to ensure compliance with international humanitarian law, a number of measures have to be taken, including providing guidance to the mission so that military operations are carried out in accordance with the rules of international humanitarian law concerning the conduct of hostilities, establishing procedures so that any persons captured by the mission are handled in accordance with international law and standards, concluding an agreement with the host country to ensure that persons transferred by the mission to the host country are treated in accordance with its obligations and international law, and providing guidance to the mission so that any act by mission personnel that may be contrary to international humanitarian law is properly addressed. The Secretariat will continue to make every effort to ensure that relevant peacekeeping operations comply with international humanitarian law, and it counts on the support of the Security Council and Member States in that regard. Thank you, Mr. President.
I thank Mr. de Serpa Soares for his briefing. I now give the floor to Mr. Peter Maurer.
Mr. President of the Security Council, Excellencies, dear colleagues, thank you for convening this session and for the opportunity to brief you today. This year marks an important milestone, 70 years since states convened to adopt the historic 1949 Geneva Conventions in the aftermath of the Second World War. In doing so, they made a critical declaration that even in armed conflict, even between fierce enemies, there must be limits on the suffering that we can inflict upon each other. The Geneva Conventions symbolize our enduring and common humanity, rooted in ideas which have existed in all civilizations. They limit the devastating effects of warfare. Today, the universally ratified Geneva Conventions represent one of the greatest achievements of interstate cooperation. The conventions show us what is possible when states take collective and individual action to uphold the law and humanitarian principles. International humanitarian law does not ask the impossible. States were not carried away by lofty ideals when they negotiated the treaties. They knew the realities of war, and they set out inherently pragmatic rules to protect and respect human life and dignity. Through the 4 Geneva Conventions, protections are given for wounded and sick soldiers on land and at sea, prisoners of war and civilians. In addition, a major achievement in 1949 was the inclusion of Article 3, my colleagues have just mentioned it, common to all 4 conventions, which provides protections in conflicts involving non-state armed groups. Today, IHL, international humanitarian law, remains a key tool for states to deal with contemporary challenges of conflict, including counterterrorism operations in armed conflict. IHL strikes a balance between military necessity and humanity. Every single day, international humanitarian law is at work saving lives and protecting women, men, and children in conflicts around the world. We rightly hear about the violations because of the consequences which are tragic and visible. But we must also recognize the protective power and positive impacts when international humanitarian law is respected. The impacts of IHL are visible in the events that take place when the wounded and sick are evacuated to safety, when people detained are treated with dignity, when the fate of missing people is finally clarified, when humanitarian assistance is delivered across front lines. The impacts of IHL are also shown through acts of restraint, when horrors are not inflicted. Civilian areas are spared from direct shelling. Medical workers are able to freely operate without threat or targeting. When respected, international humanitarian law reduces the risk of physical and social damage to communities over a long term. In this area of protected conflict, people are living through a war and violence for years or even decades, and some semblance of day-to-day life must continue. When IHL is respected, the entire collapse of towns and cities can be avoided, meaning fewer people are displaced and schools, hospitals, and markets remain open. Dear colleagues, while the Geneva Conventions are universally ratified, it is clear by the obvious terrible suffering in today's conflicts that they are not universally respected. Too often ICRC sees the impact on people when IHL is violated: indiscriminate killing, torture, rape, cities destroyed, psychological trauma inflicted. But continued violations of the law do not mean the law is inadequate. but rather that efforts to ensure respect are inadequate. We can and must do more. You can do more. Experience tells us that when it comes to violations of IHL, it is not only the knowledge of the law that counts, but the translation of the knowledge into behavior. The challenge is to ensure not only that the law is integrated into formal doctrine and military procedures, but that it also becomes an ethical standards of behavior among forces and individuals. That fighters facing a choice to act in violation of the law know and say, this is wrong, this is not what I am. On this anniversary, we call on states to be vigilant, to keep watch over their legal responsibilities and continue to take practical steps for ambitious interpretation and thorough implementation of the law. States can do more, ratifying all IHL-related treaties, strengthening military doctrine, rules of engagement and practice, ensuring military training socializes the rules and principles of IHL, developing national legislation which is compatible with international obligations, and training parliamentarians and legal professionals on international humanitarian law, and more. It is a task of ensuring that the words of the Geneva Conventions do not remain dormant in legal texts, but instead are known, applied, and championed. As a living document, the way the law is understood must reflect present-day realities. There is no doubt that the modern battlefield is a complex arena. Urbanized warfare, an increasing number of armed groups, partnered warfare are posing new and difficult dilemmas. Rapidly developing technologies are creating new front lines in cyberspace, as well as new ways to fight, for example, autonomous weapon systems and remote technologies. With these new challenges ahead, we need to consistently reflect on the meaning and development of international humanitarian law to meet the challenges of warfare today and in the future. The ICRC is working with states on the application of basic IHL concepts in these emerging fields, and we ask that they engage in constructive and open dialogue with us on these important issues. The world cannot afford to miss the opportunity to preserve humanity on these new frontiers. Dear colleagues, Mr. President, the Geneva Conventions are for all of us. They represent the line of our common humanity and they shield us from our own barbarity. We cannot forget this. This anniversary offers us an encouragement that respect for the law is both possible and desired by all of us. It is also a call to do more, to do better, and to live up to our responsibility during times of conflict to respect life and dignity. Mr. President, I thank you.
I thank Mr. Maurer for his briefing. I now give the floor to Ms. Annyssa Bellal.
Thank you, Mr. President. First of all, I would like to thank the Security Council, also in the name of the Geneva Academy of International Humanitarian Law and Human Rights, for inviting me to share with you some thoughts on the occasion of this important anniversary, from the perspective of a scholar, practitioner, and teacher of IHL to younger generations. These younger generations uses Twitter intensively. So before coming here, I tweeted to ask them what they thought was the key message I should convey to you today. And one message was repeatedly mentioned: the importance of Common Article 1 to the 4 Geneva Conventions and the obligations it contains to respect and ensure respect for the conventions in all circumstances. To put it in more prosaic terms, again, speaking to students, I often say that Article 1, that requires the respect of IHL, is an everlasting reminder of the central value underpinning any legal system, that our common humanity must be the measures of all things, and that we need to ensure respect for IHL because ultimately we are all in this together. I will then build my remarks around Common Article 1 and will develop 3 specific points illustrating this idea that we are all in this together. First, the protracted nature of contemporary armed conflicts and the value of IHL mainstreaming. Second, the prevalence of non-international armed conflicts and the needs to increase ownership of humanitarian norms among armed non-state actors. And third, recognizing the benefits of peer pressure. Let me start then with my first point. One unfortunate feature of contemporary armed conflicts is their protracted nature. As such, they have long-term consequences on civilians who are unable to live their lives normally, often for decades. It also deeply impacts the mental and physical health of all those facing such traumatizing events, reducing the possibilities to build a solid future in the aftermath of a conflict. In these circumstances, no institution can afford to work in isolation. Other bodies of law, such as human rights or refugee law, are obviously relevant, but also are the norms pertaining to human, economic, and social development. Because international humanitarian law may remain applicable for a long period of time in a given situation, there is a need to mainstream IHL in all pertinent legal systems and build bridges between implementing institutions to create efficient, coordinated, and more integrated responses to prolonged situations of violence. This is already done so to a certain extent. For example, on the 15th of April 2019, the World Health Organization, WHO, denounced the violation of IHL in the context of the combats between the different parties to the armed conflict in Libya, in which in one single day, 140 persons died and more than 600 were injured, among them medical personnel. This call to respect IHL by an institution for which IHL is not necessarily the primary mandate is interesting, even more so when we know that the words international humanitarian law or even armed conflict are not mentioned once in the WHO Constitution. This, to me, is a sign that the global international community feels the need to be more involved in the implementation of humanitarian norms, and I believe it is a good thing. There is no need to reinvent the wheel. Creating new ways to implement IHL using existing mechanisms is possible. It is well known that the financial and economic rebuilding of a country coming out of a conflict can lead to a more sustainable peace and benefit the reconstruction of the society. The UN Peace Building Fund, for example, precisely aims, and I quote from the website, at providing for a more sustained engagement in support of countries emerging from conflict and supporting peace-building activities which directly contribute to post-conflict stabilization. The fund, though, is also available as an immediate response facility, typically for countries that are within 5 years of conflict or have a significant risk of relapsing into conflict. In these situations, IHL often remain applicable. Thus, out of the 33 countries that receive funding from the United Nations Peacebuilding Fund, at least 11 of them are in a situation of armed conflict in which IHL is applicable. As a way to implement Common Article 1, one could imagine some kind of conditionality between the behavior of the parties to the conflict and the financial aid they may receive through the fund, of course, without prejudicing the civilian population. Let me now continue with my second point. According to the latest figures, for several years now, the majority of armed conflicts are of a non-international character, that is that they involved armed non-state actors. The existence of these actors is often the symptoms of deeper societal issues, but it is not the object and purpose of IHL to evaluate the legality or legitimacy of the resort to armed violence of any party to the armed conflict, be it a state or a non-state actor. What matters is the protection of the civilians and those who have laid down their arms. The Geneva Conventions, their additional protocols, and customary international humanitarian law have evolved to address and regulate the behavior of armed non-state actors. It is today uncontroversial that organized armed groups are bound by IHL, including on norms pertaining to conduct of hostilities. It has been long recognized by humanitarian actors, but also by international organizations, including the UN, that engaging armed non-state actors on compliance with international norms is a critical element in any effort to strengthen the protection of civilians. According to a recent study, at least 5 different UN organs and agencies have drafted policies or guidelines on engagement with armed non-state actors. The UN OCHA, the PKO, the UNSGA, the UN UNICEF, and UNHCR. However, how armed non-state actors understand international humanitarian norms, how they value them, or to what extent they have the necessary capacity to actually implement these norms are issues which have been neglected by the international community. Academic and policy research has shown that if one strives for better implementation of IHL, humanitarian norms must be reflected in the local norms and values of armed groups. In other words, it is important to increase their ownership of international law. In May of this year, you held a briefing on the impact of counterterrorism legislation on IHL and humanitarian action. I will not repeat here the debate, only to say that labeling any kind of armed non-state actors as terrorist group obviously limits the possibility of humanitarian engagement with these actors. But more generally, experts tend to agree that it is also important to consider armed non-state actors not only as perpetrators of violations of international law, but also as actors who can play sometimes a positive role in the implementation of IHL, if only because they are often very close to their constituencies. I will now turn to my third and final point on recognizing the benefits of peer pressure. Evaluation among peers is a well-known process in the scientific community. Any article will always be peer-reviewed before publication in a scientific journal. Even fiercer are the evaluations by your own students on any possible aspect of your teaching skills. It is by no means agreeable to read about one's limitations, one's weaknesses in the elaboration of an argument and capacity to convince. But the beauty of peer reviews is that they always lead to a better final product, a product which is more pertinent and one which meaningfully contributes to the general debate. Since the 32nd International Conference of the Red Cross and Red Crescent movement, states have tried to find ways to strengthen respect for IHL. Even if consensus has not been found yet, all states reaffirmed that IHL remains the appropriate international legal framework for regulating the conduct of parties to armed conflict, and reiterated their willingness to work towards improving its implementation. At the international level, mechanisms like the Universal Periodic Review has proved to be feasible for matters as sensitive politically as respect for human rights norms. Recognizing the benefits of peer pressure remains an interesting way forward to better the overall system of IHL protection. Allow me to finish my remarks by quoting a novelist whose words were also of universal reach and who just left us last week. In her acceptance speech for the Nobel Prize on Literature, Toni Morrison emphasized the importance of language, and I quote her, partly as a system, partly as a living thing over which one has control, but mostly as an agency, as an act with consequences. In 1949, the language of the Geneva Conventions laid the foundation of an innovative and courageous legal system. As a lawyer, I of course believe in the power of the law. But so do humanitarians that take immense risks to alleviate the suffering of others. So do students and scholars that discuss for hours the significance of a particular treaty provision. And so do you, states and the United Nations Security Council, when you debate and adopt resolutions on the protection of healthcare, of the rights of children in armed conflict, and on women and persons with disabilities in armed conflict. But because you are states, because you are the UN Security Council, in a state-centric system like ours, you are the ones that have control. You are the ones to be the agents of change and have this immense privilege to be able to act with consequences towards a better respect of the Geneva Conventions and to ensure their respect for the sake of our common humanity. And we, scholars, students, humanitarians, and of course victims, count on you because we are all in this together. Thank you for your attention.
I thank Ms. Bellal for her briefing. I shall now make a statement in my capacity as the Minister for Foreign Affairs of Poland. Excellencies, distinguished briefers, ladies and gentlemen, first let me thank Mr. Miguel de Serpa Soares, Undersecretary General for Legal Affairs and United Nations Legal Council, Mr. Peter Maurer, President of the International Committee of the Red Cross, and Ms. Annyssa Bellal of Geneva Academy of International Humanitarian Law and Human Rights for their informative briefings. Ladies and gentlemen, yesterday we celebrated 70th anniversary of the Geneva Conventions, as they are ratified and acceded by almost every state of the world. The principles and legal norms enshrined in these conventions are also recognized as customary international humanitarian law and are universally applicable. This is a rare quality of any multilateral treaty. The 4 conventions have been supplemented by 3 additional protocols, and together they constitute a significant body of law that has played a vital role in limiting brutality of armed conflicts. From the first days of Poland's membership in the Security Council, we have pursued the priority of strengthening of international law. It has always been an issue of particular importance for Poland because of our difficult history, painfully affected by consequences of other states' failures to comply with international agreements, and by reason of our sense of responsibility for the maintenance of international peace and security. If we want to protect victims of wars, we must ensure respect for principles and rules of humanitarian law codified in the Geneva Conventions since 1949. Consequently, we have been confronted with difficult questions. How is it possible that so many people suffer from brutality of warfare? And what is even worse, how is it possible if its conduct is regulated by the most widely accepted and universally applicable treaties in international relations? Eagerness to find the answer brought us to the following. Firstly, the great challenge to protecting human life in modern conflict is observance of and respect for the existing rules by the armed forces and non-state armed groups. These violations of humanitarian law occur for a number of circumstances: brutal conduct of warfare, willingness to intimidate opponents, or feeling of impunity of perpetrators. If existing rules were followed, much of the human suffering in contemporary armed conflicts would not occur. Secondly, we face new developments in present armed conflicts which demand appropriate practices and policy consistent with international humanitarian law. In a modern armed conflict, major role is played by non-state actors. The actual fighting is conducted in densely populated urban areas with frequently appalling consequences for civilians. Actors still oftentimes try to find soft targets, first and foremost the civilians. Artificial intelligence and autonomous weapon systems, such as military robots and cyber weapons, reduce the role and control of human factors during wartime. A lot of existing weapon systems are likely to cause indiscriminate harm to civilians. Especially, two principles of international humanitarian law deserve the attention. Firstly, the obligation to protect civilians, prisoners of war, the wounded, and shipwrecked. Secondly, limitations to the rights of parties to an armed conflict on how they conduct operations and on their choice of weapons. Ladies and gentlemen, this new reality of modern conflict, increasing role of non-state actors, and legal loopholes of international humanitarian law hinders the application of international humanitarian law in many ways. The complexity of new challenges impedes the process of classification of conduct situations and makes it difficult to determine the exact rules that may be applied. For example, only a small part of international humanitarian law may be applied to non-state actors. It also poses a question whether the emergence of non-state actors and new means of combat require a revision of international humanitarian law, or whether the existing rules are sufficiently adaptable to frame these new challenges. Poland takes the view that international humanitarian law needs to be protected by way of its implementation. However, its further development and adjustment to the new challenges need to be pursued. Finally, there is a problem of insufficient or even lack of accountability for violations of international humanitarian law. This is a systemic weakness that is not new. A great Polish lawyer, author of the legal term of genocide, who made significant input to international humanitarian law, Raphael Lemkin, put it very bluntly. Why is the killing of a million a lesser crime than the killing of an individual? It is the international community's role to ensure that impunity be removed and remedies for victims of violations be provided. Impunity may be eradicated only by prosecuting alleged perpetrators. This lies first and foremost on states. It is helped by mutual legal assistance through judicial cooperation and collaboration with International Criminal Court. It should be our goal to create the reality where no state and no perpetrator may be above the law, and no person is outside the protection of the law in situation of armed conflict. Ladies and gentlemen, in today's discussion, we will address many questions regarding to applicability and future of international humanitarian law. I believe that the present and future members of the Security Council will continue that effort to find solutions to challenges in front of international humanitarian law. I resume my function as President of the Council. Now I give the floor to His Excellency Mr. Heiko Maas, Federal Minister for Foreign Affairs of Germany.
Thank you very much. Excellencies, ladies and gentlemen, dear Jacek, thank you very much for convening this meeting today. And I remember only 2 weeks ago, Jacek, we commemorated the 75th anniversary of the Warsaw Uprising together. In the final months of the Second World War, 200,000 innocent men and women, most of them civilians, were murdered by German soldiers. And the city of Warsaw was left in ruins. It was crimes like this that led the international community to proclaim never again. And the Geneva Conventions were adopted. And to this day, they remain one of the humanity's proudest achievements. The alternative, war without limits, is simply not acceptable. The Geneva Conventions are the cornerstone of international humanitarian law, and their spirit is upheld by the brave men and women in humanitarian operations worldwide who dedicate their lives to saving the life of others. And while they are doing their job, we have to ask ourselves, are we really doing our job? Of course, humanitarian issues have become regular items on the agenda of the Security Council. The Council is more frequently briefed by experts whose credibility is beyond any doubt, people like our briefers today. They make sure that attacks on humanitarian actors and violations of humanitarian law are addressed clearly. But can we talk about progress when humanitarian crises are multiplying, especially in context of armed conflict? What does it say about this council when we meet time and time again and people are still dying? Respect for humanitarian law is declining, and the complexity of modern warfare with extremist groups and conflicts without borders adds new deadly challenges. Day after day, civilians, humanitarian workers, and medical personnel are attacked. Hospitals and schools are targeted. Just recently, a hospital supported by the German government and its humanitarian partners in the Syrian town Kafranabel was attacked twice. This is just one example of many. We are failing the most vulnerable. We are not living up to our legal and ethical obligations. Mr. Maurer, Peter, you once said, peace remains the ultimate goal of neutral and impartial humanitarian work, and that goal is highly political. And I agree. It is a threat to peace and security when thousands of people die, when tens of thousands fear for their lives. And ladies and gentlemen, when the most basic principles of humanity are at risk, this Council must take action. It is our duty to do so. You might not agree on political solutions to many of the world conflicts. That is the sad reality. But we must bridge our differences when our only task is to protect human lives. So let us live up to the principles we all agreed on 70 years ago. Let us bring those who attack humanitarian workers and violate the Geneva Convention to justice. This is why Germany supports organizations that document war crimes in Syria. The perpetrators must know that they will not go unpunished. And let us use our influence to ensure that all parties of conflicts fully respect humanitarian law and principles. The goal of humanitarian diplomacy must be to spread knowledge on international humanitarian law, just as the German armed forces already do whenever they carry out training missions abroad, such as in Mali. And let us back those who negotiate every day on humanitarian access. Their success saved human lives. Institutions like the Geneva-based Center of Competence on Humanitarian Negotiation deserve our full support. Ladies and gentlemen, these are concrete steps we can take today, not tomorrow. They are part of the humanitarian call for action that Germany and France initiated during our joint presidency of the Security Council in March and April. Our meeting today is an important step forward. We invite all member states, starting with the members of the Security Council, to join us. And ladies and gentlemen, we must not forget the lessons that humanity learned 70 years ago. For those who saw the horrors of World War II, the Geneva Conventions became a sign of hope. And they still are today, if we finally implement them. Any progress we made will save lives of many, and it's our duty to try it. Thank you.
I thank His Excellency Mr. Mas for his statement. I now give the floor to the representative of China.
Thank you, Mr. President. Mr. President, the Chinese delegation would like to welcome you and thank you for presiding over the Security Council meeting once again. I would like to welcome the Federal Minister for Foreign Affairs of Germany, Mr. Mas, for coming to this meeting. I thank USG Suarez and ICRC President Mario for their briefings. We have listened attentively to the statement by Ms. Bellal. 70 years ago, in the aftermath of 2 world wars, the international community, after painful reflection, came together, revised and made improvements to the Geneva Conventions, and further developed and supplemented them by adopting the additional protocols. The principles of humanity, differentiation, military necessity, proportionality, and prohibition of reprisals were established with protection at the center. These shining principles of humanity received universal support from all countries in the world in a strong and important manifestation of multilateralism. 2 decades ago, the protection of civilians in armed conflict was added to the agenda of the Council, paving the way for the further development and consolidation of the principles of international humanitarian law. At present, the international security situation remains grave and fraught with new dynamics. The traditional and non-traditional security threats are intertwined. Armed conflicts in some regions have protracted or even escalated, causing serious concerns to the international community. Promoting peaceful settlement of disputes through dialogue, upholding IHL, and carrying forward the international humanitarian spirit are of great significance. China would like to emphasize the following points. First, governments concerned and parties to the conflict must earnestly fulfill their obligations under IHL. Governments in all circumstances bear the primary responsibility to comply with IHL, and this role is irreplaceable. The conduct of parties to conflict in disputed areas should be governed by IHL. In situations where conflicts are inevitable, the principles of IHL should be upheld to prevent the indiscriminate use of force or acts that disregard humanitarian consequences. Any violation of IHL should be investigated and punished according to law. Second, the international community should play a constructive role in helping the relevant parties to strengthen capacity building in implementing their obligations under IHL. China appreciates the effort of ICRC in adhering to the principles of neutrality, impartiality, and independence, and its long-standing contribution to the wide dissemination and effective implementation of the Geneva Conventions and their additional protocols. Humanitarian agencies, on the basis of full respect for sovereignty of the countries concerned, should promote humanity, compassion, and dedication, and engage in training, legal consultancy, technical support, and experience sharing to ensure the effective implementation of the principles of IHL. Third, The implementation of IHL should be strengthened with a focus on enhancing the effectiveness of the existing mechanisms of IHL. At present, the continuous development of cyber technologies, AI, and high-tech weapons, frequent occurrence of non-international armed conflicts, and terrorist attacks pose challenges to the implementation of IHL. The international community should proceed from the practical needs of applying and complying with IHL and build on the consensus of countries to reach a broad agreement on addressing current challenges and strengthening the implementation of IHL. Fourth, the Security Council should attach great importance to tackling the underlying causes of conflicts by addressing both the symptoms and the root causes. Conflict prevention, reduction, and resolution, and peaceful settlement of disputes are best approaches to upholding the spirit of IHL centering on protection. At the heart of the collective security mechanism, the Security Council should earnestly fulfill its primary responsibility for maintaining international peace and security and encourage parties to dispute to fulfill their obligations to implement Council resolutions and resolve conflicts through dialogue, consultation, and political negotiations. The international community should establish a common, comprehensive, cooperative, and sustainable security concept, build partnerships by way of choosing dialogue over confrontation and partnerships over alliances, and create a world of lasting peace and universal security. We should build a community of shared future for mankind, advocate a global governance concept of extensive consultations, joint contributions, and shared benefits, and strive to create a peaceful and stable international environment. Mr. President, China was among the first countries to accede to the Geneva Conventions and their additional protocols. Over the years, the Chinese government has been taking useful and practical measures to implement, study, and disseminate IHL, including strengthening relevant domestic legislation, conducting training and advising in the Army, and carrying out IHL education and publicity activities throughout the society. In 2007, the National Committee of International Humanitarian Law was established to promote the dissemination and implementation of IHL in China. China stands ready to continue to work with all parties to make greater contributions to the development and implementation of international humanitarian law. Thank you, Mr. President.
I thank the representative of China for his statement. I now give the floor to the representative of the United Kingdom.
Thank you very much, Mr. President. Thank you for convening this important event on an important anniversary. Thank you for being with us today, and thank you too to His Excellency the German Foreign Minister for being here. It was very good to hear from our briefers, from the Under-Secretary General, from Dr. Bellal, and of course from President Mara. The ICRC is one of the oldest international organisations. They gave us a very good context for why we're meeting today and why IHL remains so important. It provides a robust legal framework for the protection of all civilians and combatants, and it's a vital tool in ensuring humanity remains even in the worst of conflict situations. For the United Kingdom, support for international criminal justice and international humanitarian law is a fundamental element of our foreign policy. We hold an annual meeting with the British Red Cross to review compliance. The UK has a strong history of upholding and promoting international humanitarian law, and we consistently call on states and non-state actors engaged in armed conflict to respect IHL and to act in accordance with their obligations under it. The United Kingdom believes that justice and accountability for the most serious international crimes is not only right in itself, it is also crucial to building lasting peace and security. Mr. President, in March, we published our first voluntary report on the implementation of IHL at the domestic level. We invite other states to join us and publish the steps they are taking to improve compliance. My government also believes that the International Criminal Court has an important role in pursuing accountability when national authorities are either unable or unwilling to do so. We contribute to the International Criminal Court, international and hybrid tribunals, and we provide training and other support to member states wanting to enhance their own justice systems. We believe that our support helps strengthen the rules-based international system, and it helps tackle impunity for serious violations of international humanitarian law. Mr. President, the adoption this year of Security Council Resolutions 2462 and 2484 and their increased focus on the protection of impartial humanitarian activity in a counter-terrorism context helps to address an increasingly complex nexus around modern warfare. The 33rd Quadrennial International Conference of the Red Cross and Red Crescent on IHL will take place in December 2019. We are looking forward to participating, and we will be hosting a session as part of the international conference on the voluntary report I mentioned earlier to share our experience and hopefully get a corpus of best practice. And in November this year, we will host a Preventing Sexual Violence in Conflict international conference called Time for Justice, Putting Survivors First. The event will mark 5 years since the Global Summit to End Sexual Violence in Conflict. Our Special Representative on PSVI, Lord Ahmed, will lead the event, and we hope to pursue deliverables against 3 key objectives: securing justice and accountability, tackling stigma, and preventing sexual violence in conflict. As we all know, Mr. President, and as you yourself enumerated, there are ongoing violations of international humanitarian law in multiple conflict zones. We need to work together, using all the tools available as members of the Security Council to achieve this, as the Chinese representative said a moment ago. Working with states to implement training on IHL, call for greater accountability and information when attacks happen, and sharing expertise between governments are some of the things we can do. Mr. President, I'd like to use this debate to shine a spotlight on a few specific situations where the IHL situation is dire. In Ukraine, citizens in Crimea have been denied access to basic services because they would not change their citizenship, contrary to IHL. In South Sudan, it is clear that justice, truth and reconciliation are fundamental to rebuilding that society, and all parties must ensure transitional justice under Chapter 5 of the revitalised peace deal is implemented in full. In Mali and the Sahel, the deteriorating security situation has brought reports of violent international humanitarian law violations and abuses by armed militia, terrorist armed groups and regional security forces. But it is in Syria, Mr. President, that the adherence by the parties to the conflict to international humanitarian law has reached a nadir. The Syrian people have faced forced starvation. They have been subject to arbitrary detention with no access by the ICRC. They have been driven from their homes in Aleppo and elsewhere. They have had weapons of mass destruction used against them in Aleppo and in eastern Ghouta, as verified by independent bodies. And now, as those displaced from Aleppo join the terrified residents of Idlib, they find their schools and their hospitals being bombed. As we've said in this council several times, this is in defiance of IHL, and it defies humanity. It undermines any claim by the Syrian authorities to want to rebuild their country. Mr. President, we still have not had answers as to how a return to IHL compliance will be achieved. We've not had answers as to how Russian and Syrian forces are implementing deconfliction and protecting hospitals. We still have not had answers as to why the Syrian authorities are bombing hospitals as admitted in their letter to the Security Council without following the Geneva Conventions and without giving the due warnings that those conventions demand. The United Nations Secretary-General has established a board of inquiry to examine these questions, and this is welcome. And I take the opportunity to recall that commanders on the ground have individual, personal responsibility to uphold international humanitarian law. They will be held individually and personally accountable for violations which may amount to crimes against humanity or war crimes. Justice may not come tomorrow, Mr. President, but it will come. As far as the United Kingdom's contribution goes, we have given over £2.8 billion, so over $3 billion in response to the Syria crisis, which is our largest ever response to a single humanitarian crisis. But with over 400,000 people who have died, over half a population displaced, with 6.2 million people fleeing their homes, and over 5.6 million taking refuge in neighbouring countries, and 11.7 million people are in dire need of humanitarian assistance, it is clear, Mr. President, that the end to this conflict cannot come too soon. As President Mara reminded us, there are increasingly complex aspects to warfare at the moment, especially concerning urban conflict. We have more non-state actors involved in conflict than before. Conflicts are lasting longer, and they lead to complex and protracted crises. Of the 20 largest humanitarian aid countries, 17 have been receiving international support for 8 consecutive years or more. The Council must continue, Mr. President, to draw attention to these points. And in several non-international armed conflicts, agencies of states are involved overtly or covertly. These are very complex areas, and they require our further attention and study. Only collectively can we address the increasingly difficult and intertwined nature of modern conflict. Finally, Mr. President, it's clear we need more action. As President Mara said, the laws of conflict were designed to be inherent and pragmatic. They were designed not to be an aspiration difficult to attain, but to be followed so they could reduce suffering. We need to continue to spotlight violations by any and all actors. Only by doing so can we have a stake in upholding and strengthening our common humanity. Thank you, Mr. President.
I thank the representative of UK for her statement. I now give the floor to the representative of South Africa.
Mr. President, I'm delivering this statement on behalf of the African members of the Security Council, Cote d'Ivoire, Equatorial Guinea, and South Africa. We'd like to thank the briefers this morning for their comprehensive briefing and for particularly emphasizing the importance of respecting international humanitarian law. We also want to welcome the Federal Minister for Foreign Affairs of Germany, Minister Heiko Maas. Mr. President, allow us to also thank Poland for organizing this briefing on international humanitarian law, IHL, on the 70th anniversary of the Geneva Convention. The 4 Geneva Conventions of 1949 formed the cornerstone of IHL, and they've been complemented by the 2 additional protocols of 1977, and Additional Protocol 3 of 2005. The adoption in the aftermath of the Second World War firmly established that those who are not or no longer taking direct part in hostilities, the sick, the prisoners of war, including civilians living under occupation, must be protected and their dignity upheld without adverse distinction. We wish to urge the obligation by all parties involved in armed conflict to respect IHL in all circumstances. We are disturbed by the reports of war crimes in some parts of the world and the tremendous harm on civilian populations and vulnerable persons, which illustrates blatant violations of IHL. Thousands of people continue to bear the brunt of armed conflict, particularly women and children, and have been forced to leave their homes, sometimes taking extreme dangerous routes to seek refuge in safer countries far away. Additionally, victims and their communities must be given access to resources in order to limit the negative effects such crimes have been on societies. In some armed conflict, parties to conflict have often resorted to the recruitment of children and have used sexual exploitation and abuse atmosphere of war. In such armed conflicts, ensuring the respect of IHL has been extremely challenging, and there is a clear, serious compliance deficit. The international community has the obligation to address this situation urgently. We remain grateful to the International Committee of the Red Cross, Mr. Peter Maura, for their continued commitment to preserve human lives, dignity, and well-being. We commend the ICSR outstanding work in their quest to reach people who are yearning for humanitarian assistance and relief. The ICRC continues to contribute to the development and implementation of international mechanisms and framework for effective humanitarian assistance to people that are negatively affected by war and armed conflict, particularly women and children. Mr. President, conflicts have evolved in recent years, and the new emerging nature of conflicts and the resurgence in violation of international humanitarian law, which compels peoples to seek refuge elsewhere, is concerning. We have witnessed an upsurge of violent extremism and terror attacks in which thousands of innocent civilians are being targeted by armed terrorist groups. In this new era of extremism, the historical respect of aid workers, medical personnel, schools and hospitals, and other essential civilian facilities no longer stands. Our historical heritage and cultural property continue to be indiscriminately disseminated. At the same time, communities that have traditionally lived in peace are now turning to each other violently as they compete for access to resources. Some armed conflicts are playing out in Africa and delaying the achievement of peace and security as a prerequisite for Africa's prosperity. This challenge becomes more alarming with the changing face of contemporary armed conflicts. Modern technologies has brought many positive developments, but on the grim side, it is increasingly characterized by the use of an array of new and lethal methods of warfare, including remote control weapons and automated systems that contribute decisively to the dehumanizations of war. Their use and the destruction they can cause have serious legal, ethical, moral, and practical implications for IHL. We underscore the need to respect IHL and international human rights law by all parties to armed conflict. Access to people in distress in conflict areas by humanitarian workers remains a serious challenge and a cause for concern. As a Security Council, we need to ensure that unfettered access and priority to the security of humanitarian workers in prioritized areas. Otherwise, this insecurity will persistently inhibit efforts to provide humanitarian assistance to people in need and relief. Mr. President, the root causes of war crimes, including abject poverty, the invasion of women's rights, and political corruption must be addressed. The best way to ensure respect for international humanitarian law and to end the suffering of civilians and vulnerable persons is to prevent armed conflicts. Conflict prevention and inclusive dialogue remain critical mechanisms that have proven to be effective in averting possible deadly conflicts when combined with strong political will and support from regional and international partners. This Council has a responsibility to redouble its efforts to prevent and resolve conflicts in its quest to maintain international peace and stability. We cannot overemphasize accountability as critical to ensure respect for IHL. Likewise, impunity must be eliminated. The responsibility to end impunity by prosecuting illegal perpetrators for the crimes against humanity and war crimes first lies with the states, including through the improved ways of mutual legal assistance. In conclusion, the Geneva Convention and relevant protocols are strongly supported. Our aim should be that respect for IHL is strengthened and enhanced. We believe that the relevance of the Geneva Convention remains intact in its 70th year of existence, and its implementation should be encouraged in order to ensure the continued protection of civilians. I thank you, Mr. President.
I thank the representative of South Africa for his statement. I now give the floor to the representative of Kuwait.
شكرا سيد الرئيس. نرحب.
Thank you, Mr. President. We welcome your presence here today. We welcome the convening of this meeting, and we would like to welcome the Minister of Foreign Affairs of Germany. We also applaud Messrs. Suarez and Moira and Ms. Bellal. We thank them for their interesting and thorough briefings. With the passage of time and moving from one generation to another, it's important to recall why the Geneva Conventions came about and to consider the obstacles that hinder the implementation of their objectives. We therefore welcome the organization of meetings and events to fix the spotlight on the importance of this legal system, which guarantees human rights during conflict. Mr. President, we are commemorating the 70th anniversary of the Geneva Conventions this year, adopted in 1949, which was signed following the most devastating war the world has ever seen, the Second World War. This very organization, the United Nations, was created following that war because of its terrible losses in human lives and to prevent the breakout of another equally devastating war. But the violence and suffering that we see in conflict-affected areas and which we have seen in past decades are hardly less than the violence and suffering that the world witnessed during the Second World War 74 years ago. Therefore, consolidating the rule of law, and in particular international humanitarian law, is more important than ever. The 4 Geneva Conventions and their additional protocols are the vitally important legal framework for humanity during war and armed conflict. Those conventions were ratified, but they do not enjoy respect, the necessary respect and compliance. We can see that these texts are ignored and neglected, and an example of that is what is happening in the occupied Palestinian territories in Syria and concerning the Rohingya minority. The question, therefore, is how to put an end to these violations, how to alleviate the suffering of human beings, the tragic suffering that we see in conflict zones. The response is very much the point and essence of this debate today. So by consolidating the rule of law and ensuring that humanitarian principles are respected during armed conflict. And the most important question is, therefore, how do we achieve that? First of all, and above all, the United Nations and the Security Council in particular plays a crucial role in upholding international humanitarian law and consolidating the rule of law by guaranteeing the full and complete implementation of the relevant resolutions of the Security Council, notably those concerning the protection of civilians and compliance by international organizations on the ground and parties to the conflict with international humanitarian law. The UN's Blue Helmets are also responsible for protecting civilians by taking the necessary measures within their mandates, notably ensuring the security of displaced persons camps, the medical evacuation of the injured, and strengthening the capacities of the national police forces. Secondly, it is necessary that there be accountability for war crimes, genocide, and crimes against humanity. All the violations of human rights must be condemned by all parties in any conflict. It is also necessary to ensure that those responsible for attacks against civilians are held accountable. Sanctions regimes can play an important role when it comes to accountability by those who violate international humanitarian law and international human rights law if those regimes are used effectively and transparently. Thirdly, and lastly, we, as members, have a responsibility to ensure that international law is respected more exhaustively through the adoption of precise and practical measures. We have priorities and national priorities which may differ, and it is sometimes difficult to unite around a position every time. However, this should not undermine our obligations and our responsibilities under international law. notably when it comes to the humanitarian aspect and humanitarian assistance, as well as access to that humanitarian assistance for those who need it. And here, we stress the importance of not using the right of veto and not applying it when it comes to ensuring access for those in need to humanitarian assistance. Efforts could also be made bilaterally through the sharing of experience between countries and by coordinating our efforts, notably by calling on the parties to a conflict to respect their obligations under IHL. Thank you, Mr. President.
I thank the representative of Kuwait for his statement. I now give the floor to the representative of the Dominican Republic.
I would like to thank the Presidency for convening this meeting today and to the speakers for their exhaustive comments. And in particular, I would like to thank Mr. Peter Maurer and express the heartfelt thanks of my country for his work and to the International Red Cross as guarantors of these conventions. This meeting provides us with a unique opportunity to commemorate the adoption of one of the most important instruments in safeguarding the security and human dignity in contexts of armed conflict, and to address the role of the Security Council in this area. We would also like to recognize the presence amongst us of the Minister from Poland, as well as the Minister from Germany, who have placed this subject at the heart of their agendas. Mr. President, 70 years on from its universal adoption, the norms and principles contained in the Geneva Conventions and their additional protocols continue to be relevant today. In the light of these conventions, we must think about the principal challenges that we collectively face in the area of the maintenance of international peace and security. Non-compliance with these norms of international humanitarian law continues to have unacceptable results for the civilian population caught up in armed conflict. In this context, we would stress the particular vulnerability of women, children, older persons, and persons with disabilities. Not paying attention to their specific needs leads to ongoing feelings of resentment and exclusion, which can lead to situations of violence. Be it by a decision or omission, many states are unable to comply with international humanitarian law when facing conflict situations. But moreover, very frequently it is these states which undertake offensive actions by which they elude their responsibility to protect and guarantee human rights, the human rights of all those people living within their jurisdiction. The growing proliferation and complexity of non-state actors who do not respect any law other than that of using defenseless populations to commit their atrocities is perhaps one of the most complex challenges that we face. This requires urgent action to be taken on the part of states affected and by regional and international organizations, aimed at increasing the capacity for prevention and conflict resolution through peaceful means. The prevailing situation is one of a lack of political will, both to avoid the abuse of human rights and violations of international humanitarian law, as well as to ensure that those who commit these atrocities pay the consequences for their acts. Mr. President, I would like to make some recommendations from our own perspective. We believe it is essential that we increase knowledge and training at all levels of our national armed forces in the area of international humanitarian law and human rights. In particular, women in the military and civil society, in order to make them agents of change and defenders of the principles enshrined in the Geneva Conventions. It is essential to disseminate the norms contained in these instruments using language which is accessible and exhaustive, which is adapted to the national cultural realities, taking into account minority languages used by the populations affected. As the body responsible for guaranteeing compliance with the peacekeeping mandates of the United Nations, this Council must undertake action which responds to the realities on the ground, respecting the social, economic, and geopolitical factors that influence the configuration and duration of the conflicts. We would reiterate that in this effort, our responsibility does not end with the security of civilians. Much rather, it ends when we are able to revive hope, trust in themselves, their country, their legal and political processes, and their trust in the international community. Let us unite as humankind in a renewed commitment, which will be translated into greater respect for human dignity, more justice, and less impunity. Let us hope that by the year 2089, when future generations will be commemorating the 140th anniversary of the Geneva Conventions, let us hope that we will be living in a world free of human suffering. I thank you.
I thank the representative of Dominican Republic for his statement. I now give the floor to the representative of France.
Monsieur le Président, Monsieur le
Mr. President, Mr. Minister, 70 years ago, the adoption of the Geneva Conventions marked progress in universal conscience following the horrors of the Second World War. Allow me, therefore, first of all, to commend your commitment to this subject and to thank Poland for having taken the initiative of organizing this anniversary meeting, a few months after the meeting on international humanitarian law on the 1st of April during the twinned presidencies of the Security Council of France and Germany under the leadership of the German Foreign Minister, Mr. Heiko Maas, and I welcome his participation today. And also with the Minister for Europe and Foreign Affairs, Mr. Jean-Yves Le Drian. Respect for international humanitarian law is a major priority of our diplomacy. I would also like to thank our three briefers, and in particular would like to pay tribute to the ICRC, which, as guarantor of the Geneva Conventions, plays an essential role in the struggle to spread and implement international humanitarian law. Today, these conventions and their additional protocols, for which we call for universal ratification, are all too often flouted, whether that be in Syria, Libya, Yemen, Palestine, Afghanistan, the CAR, the Democratic Republic of the Congo, or South Sudan. Some parties to conflict go even so far as knowingly including violations of these rules in their military strategies to deprive populations of any relief and force their surrender. Others violate international humanitarian law in the name of the fight against terrorism, and this is unacceptable, and it is up to our Council to very clearly and regularly reaffirm that. Mr. President, today our efforts must be intensified around three priorities. The first priority is guaranteeing access to humanitarian assistance for civilian populations. For humanitarian and medical personnel be able to have access to civilians, they must be protected from all violence and threats and must not be targeted. You do not fire on an ambulance. The Security Council marked an important milestone in including this with Resolution 2286. And it was with the aim of moving from words to actions that in 2017 France initiated a political declaration to promote the implementation of that resolution, which has currently been endorsed by 44 states. Mr. President, the second priority is preventing violations of international humanitarian law, and that is what we do when we place the protection of civilians, and in particular of women and children, at the heart of peacekeeping operation mandates, as is the case for MONUSCO, MINUSMA, and MINUSCA. As was recalled by Miguel de Sierpa Suarez, these operations, as well as non-UN forces supported by this Council, must conduct their activities, their operations, in strict respect for international humanitarian law. This is the aim of the human rights compliance framework for the G5 Sahel Joint Force. The prevention of violations of international humanitarian law, above all, relies on the conduct of each state, and the members of the Security Council should set an example in this regard. Concerning the military actions of France, international humanitarian law is included from the planning phase and is an integral part of our security and defence cooperation, notably through the training that we offer to our partners and the strategy to modernise our armed forces. As the Minister for the Armed Forces, Ms. Florence Parly, underscored on the 5th of April in her speech on intelligence and defence, the rise of artificial intelligence should not move any of the red lines set out in international humanitarian law, whether it be discriminating between combatants and non-combatants, respect for the principle of proportionality, or the minimisation of damage. On the contrary, artificial intelligence must allow us to continue to better respect these rules in the conflicts of tomorrow. Mr. President, the third priority is the fight against impunity. As you quite rightly underscored the importance of that, we must strengthen national capacities to conduct impartial and independent investigations, and when national mechanisms are insufficient or inappropriate, we must support the use of international mechanisms. France, in this respect, reiterates its call for the universalization of the Rome Statute of the International Criminal Court. It is also necessary to improve the gathering of information. The establishment of the WHO database of attacks against medical personnel and infrastructure represents major progress in this regard. We also welcome the establishment by the Secretary-General of a board of inquiry on attacks against schools and hospitals in the northwest of Syria that have been through the UN deconfliction mechanism. Lastly, sanctions are a tool of deterrence that the Council should use more frequently, in particular in respect of those responsible for sexual violence and those responsible for attacks against humanitarian personnel and facilities. Mr. President, the task before us is considerable, and now more than ever we must be mobilized together around this priority. That is why, as Minister Heiko Maas has just told us, France and Germany have launched a humanitarian call to action, which we will present in September during the high-level segment of the General Assembly. This call identifies concrete actions that states can take to strengthen respect for international humanitarian law, and we call on all our partners to endorse that. Thank you.
I thank the representative of France for her statement. I now give the floor to the representative of Belgium.
Thank you, Mr. President. Mr. President, allow me firstly to warmly thank you for organising this meeting, and I would also like to warmly thank the three speakers for their very pertinent briefings. The Geneva Conventions of 1949, the 70th anniversary of which we celebrated yesterday, are universally ratified. With their additional protocols, they constitute the key parts of the international legal framework in the area of protection of civilians in armed conflict. In so doing, international humanitarian law plays a central role in the area of international peace and security. It makes it possible to limit atrocities in the case of armed conflict, and in this way also facilitates peace processes and reconciliation post-conflict. Unfortunately, we all know that the rules of IHL are increasingly flouted. Nevertheless, we must not draw the wrong conclusions. IHL remains today more relevant than ever before. Its principles remain simple, practical, and adapted to the main developments that we have seen in warfare. It is therefore not a matter of rewriting the Geneva Conventions, but rather redoubling our efforts to ensure that they are respected and implemented. Mr. President, this Council allows me to point out some simple ways that Belgium feels would be particularly appropriate in order to strengthen respect for international humanitarian law. Firstly, we must promote the dissemination of IHL rules amongst all actors concerned. That was also pointed out by President Maura. First of all, we must include in school curricula from the very earliest age the principles that lie at the heart of IHL in order to anchor in society a culture of humanity. Then the armed forces must be trained adequately by including, for example, IHL in the teaching given to the military. Finally, public powers must apply IHL also in peacetime. We must also stress the key role played by national humanitarian law committees by providing counsel and assistance in the dissemination and implementation of IHL, but also they're of help in order to crack down on those who violate the rules. Secondly, states, be they parties or non-parties to an armed conflict, and the entire international community must take all possible measures in order to implement their obligation to respect and ensure respect for IHL. It is up to them to set an example by using their influence when they participate in a military coalition or when they support an armed non-state group as part of an armed conflict. As guarantors of international peace and security, the Security Council must also recall to member states of the United Nations and to parties into a conflict what their obligations are. Belgium will thus continue, amongst other things, to be committed to safe, sustainable and unhindered humanitarian access in Syria in our quality as co-pen holder on this dossier, and for the specific protection of children as part of our chairmanship of the Working Group on Children and Armed Conflict. Thirdly, we must ensure that no measure taken in the area of the counter-terrorism fight hinder the work of humanitarian organizations because their action is neutral and impartial. Respect for IHL remains essential everywhere and in all circumstances, and the policies which we adopt towards terrorist groups do not give us the right to depart from these rules. This is why Belgium, together with the European Union, next September, in the margins of the Ministerial Week of the General Assembly, will be organizing a high-level event on the impact of counter-terrorism measures on the humanitarian sphere. And finally and fourthly, the action of states must not just be limited to prevention. It is imperative that we combat impunity for the most serious crimes and thus deter the commission of new atrocities. Whilst this is above all the responsibility for each state, it is also up to this Council to strengthen its support for the national judicial procedures and hybrid mechanisms, but also it is up to the International Criminal Court, in particular in regard to the situations that have been referred to it. Mr. President, 70 years ago, the adoption of the Geneva Conventions was a historic moment, reflecting our shared humanity and our common values. The anniversary that we celebrate today should lead us to renew our commitment for the respect of IHL through specific measures in order to reduce as much as possible the already too numerous victims of armed conflict. Thank you, Mr. President.
I thank the representative of Belgium for her statement. I now give the floor to the representative of the United States.
Thank you, Mr. President, and welcome back to the Council. It's excellent to have you with us today. And thank you, Undersecretary General Suarez, Peter Maurer, and Professor Bellal for your briefings today. The United States would like to recognize and commend the ICRC's vital role in promoting the protection of civilians. 7 decades ago, with the horrors of World War II still fresh, representatives from around the world gathered in Geneva to try and change the way wars were waged. Building on an existing framework of law and war treaties, the resulting Geneva Conventions enshrined formal legal rules to govern the conduct of war. The conventions have played a significant role in shaping parties' behavior on the battlefield and improving protections for combatants and civilians alike. Mr. President, today's briefing is an important opportunity to reflect on the successes of the Geneva Conventions and to deepen and strengthen international compliance with and enforcement of these obligations. Much has changed in the past 70 years. New technologies have emerged which allow for greater precision in many cases, but also more deadly force. The rise of terrorist groups like Al-Qaeda and ISIS has created new challenges as states work to defeat enemies who abide by no rules whatsoever. Today, the Geneva Conventions remain some of the very few universally ratified international treaties. They're a powerful articulation of international humanitarian law and have become synonymous with ethical behavior in war. Mr. President, as UN member states, we have several tools at our disposal to address violations of international humanitarian law. In certain instances of grave and systematic violations, war crimes tribunals have been important tools to hold offenders accountable. The United States is proud to have supported the establishment of the tribunals for Cambodia, Rwanda, Sierra Leone, and the former Yugoslavia, as well as their subsequent work to punish some of the worst offenders of international humanitarian law. In other cases, however, obstacles to accountability remain. For the relevance of these conventions to endure into the future, compliance and accountability are key. While member states and parties to armed conflict are ultimately responsible for adhering to their IHL obligations, each of us has an important role to play in calling out violations and holding those responsible to account. Mr. President, we continue to push for greater compliance with the Geneva Conventions by other actors, and we are also firmly committed to respecting our own obligations. To this end, we support efforts to disseminate accurate information about IHL among all parties to conflicts. For example, the training of U.S. military personnel includes thorough coverage of IHL in principle and in practice. We also incorporate IHL adherence into U.S. training for international military partners. This includes peacekeeping pre-deployment training that we offer for troop and police contributors supporting UN and regional peace operations. We've made the protection of civilians and civilian infrastructure, as well as humanitarian personnel, locations, and missions, a high priority in conflict areas. And we know that effective protection requires full adherence to IHL by all parties to conflict. Mr. President, the United States will continue our efforts to respect and ensure respect for the Geneva Conventions. We call on all member states and the actors they support to comply fully with their obligations and to hold violators accountable. I thank you.
I thank the representative of the United States for his statement. I now give the floor to the representative of Russian Federation.
Mr. Minister, welcome to New York. We're very pleased to see you once again in the President's chair of the UN Security Council. We'd also like to thank the Undersecretary General for Legal Affairs, Mr. Miguel de Serpa Suarez, President of the International Committee of the Red Cross, Mr. Peter Maurer, and Ms. Bellal for their briefings. History has seen various different approaches to the problems of the law of armed conflicts. It's no secret that at one time war was thought to be a situation that was contrary to law and that was not subject to any regulation. This was expressed in the well-known Roman maxim, "In times of war, the law falls silent." Unfortunately, humanity needed several centuries and two of the most terrible armed conflicts in its history, which took place in the 20th century, to realize the need to humanize wars and to form a set of rules pertaining to its conduct. And this so that, among other things, those who do not directly participate in armed conflict are kept as safe as possible. Today we are meeting here to mark the 70th anniversary of the Geneva Conventions. These are documents that are the foundation of the contemporary law of armed conflicts. Our country made a substantial contribution to the development of these conventions, which substantially expanded the legal regulation of states' conduct in armed conflicts, and first and foremost when it comes to the protection of the civilian population. I would like to take this opportunity to recall another anniversary relating to international humanitarian law. In November last year in St. Petersburg, the Interparliamentary Assembly of the CIS and the ICRC organized a conference devoted to the 150th anniversary of the adoption, upon Russia's initiative, of the St. Petersburg Declaration, renouncing the use, in times of war, of explosive projectiles of 1868. This document established not only the idea of prohibiting inhumane forms of weaponry, but also excluding the civilian population and civilian objects from what are considered legitimate targets of war. Mr. President, when we speak of the significance and relevance of the Geneva Conventions, we also need to recall the history behind their creation. I don't think it would be any exaggeration to say that the Geneva Conventions were the lesson that humanity learnt from the bitter experience of the Second World War. This war, which was unprecedented in its scale and brutality, was an immense tragedy for the peoples of Europe, Asia, and the entire world. The threat to the fundamental principles of civilization was prevented through colossal joint efforts and heavy losses. As we know, Germany essentially eschewed the norms of international law that existed at the time. Peaceful towns and the civilian population were bombed. Hitler's air and ground forces pursued a scorched earth policy. There was widespread use of mass deportations of the civilian population and the collective punishment of civilians allegedly for supporting partisans. At the same time, these collective punishments, as has been demonstrated by contemporary investigations and research, aimed, among other things, to reduce the total number of the population living on occupied territories in order to free up resources that were useful for the occupying power. There was widespread use of starvation as well as a means of waging war. The treatment of prisoners of war was particularly cynical. All of this took place in spite of the fact that between the parties to the conflict there were international obligations that were applicable at the time. Germany's mass and gross violation of its international obligations was the subject of sentencing of the Nuremberg Tribunal. At the same time, the defense of war criminals during the trial actively advanced the idea that the Hague rules for the waging of war that were based on the experience of 19th century wars were outdated. Moreover, the defendants actively referred to an absence of specific prohibitions when it comes to the treatment of the civilian population. Although the justifications that they provided did not allow them to escape responsibility, they raised once and for all the question of strengthening the international legal protection of the victims of armed conflicts, and it was in those conditions that the diplomatic conference was convened, which resulted in the 1949 Geneva Conventions. At the same time, following the adoption of the Geneva Conventions, it became clear that the developing means and methods of waging war, the emergence of new forms of conflict, such as national liberation wars, and the heightened attention of the international community to upholding human rights in any situations, dictated the need for the further codification, confirmation, and development of humanitarian law. This led to the adoption in 1977 of Additional Protocols 1 and 2 to the Geneva Conventions. Mr. President, allow me to cite the final resolution of the 1949 conference and remind states that participated in the development of the Geneva Conventions of the following. The conference wishes to affirm before all nations that its work, having been inspired solely by humanitarian aims, its earnest hope is that in the future governments may never have to apply the Geneva Conventions for the protection of war victims. Its strongest desire is that the powers, great and small, may always find a friendly settlement of their differences through cooperation and understanding between nations, so that peace shall reign on earth forever. Those words remain relevant today. However, armed conflicts in various parts of the world remain a reality, and the Security Council time and again is forced to pay attention to the institutions of international humanitarian law. The nature of wars has changed. Internal armed conflicts now dominate, the main reason of which, as a rule, tends to be the undermining of statehood, including through the overthrowing of legitimate governments as a result of external interference. Selective approaches and double standards now often have an impact on the authority of IHL. And this, in turn, gives grounds for discussions about the need to uphold this branch of international law, as a rule, through some sort of declaration or additional monitoring mechanism. Moreover, in these conditions, many, depending on their political predilections, are tempted to hype up the violations of some parties and hush up the crimes of others. We are convinced that the norms of IHL should not be used as an instrument for political manipulations. Unfortunately, we've already heard an example of this situation today in the statement of our British colleague. Because our country was addressed directly, I would just like to say that clearly you have some old, outdated information, or you're poorly prepared, but the territory of the Russian Federation, which includes Crimea, does not have any armed conflict. And so talking about international humanitarian law as applies to our country is not appropriate. And turning to what you said about Syria, I can say that that is also not a subject for our meeting today. I would like to recall the many questions that we are putting to you and your American colleagues about what is taking place with the observation of IHL beyond the Euphrates. We repeatedly ask these questions, but we don't receive any answers to them. And it's probably now time to get down to doing so. Mr. President, we call on all states to strictly adhere to their obligations under international law, first and foremost the existing norms of international humanitarian law, which form a firm legal basis for the protection, first and foremost, of the civilian population from dangers arising as a result of military operations. As we have said repeatedly in this chamber, we are convinced that the problems of implementation lie not in the weakness of international humanitarian law, but rather in the disinclination or reluctance to implement its principles and norms in practice. Moreover, alongside the fundamentally important measures to strengthen and maintain peace and security, of equal relevance are also means that help to reduce the intensity of armed conflicts, to limit violence, and to create conditions for reconciliation and political settlement. Our country, in turn, continues unstintingly to call for the humanization of armed conflicts, but above all for their prevention. Thank you.
I thank the representative of the Russian Federation for his statement. I now give the floor to the representative of Indonesia.
Thank you very much, Mr. President. Let me also, like others, begin by thanking you for convening this meeting and, of course, welcoming you, Minister, for presiding on this very important topic, and also to welcome His Excellency Minister Heiko Maas to this chamber. And I also would like to thank the briefers today, Mr. Miguel de Serpa Suarez, Mr. Peter Maurer, as well as Dr. Annyssa Bellal, which has provided us with insights on what's happening with regard to the IHL as well as its implementation. And our meeting coincides with the 70th anniversary of the Fourth Geneva Convention. And this year also marks the 20th anniversary of the Council adoption of the resolution on the protection of civilians in armed conflict. All are very important milestones on what the Council has achieved thus far. Now, in this regard, allow me to reemphasize that our concerted efforts in the Council and in the UN framework are and should always be on the respect of international laws, in particular the UN Charter. And respect to the Fourth Geneva Convention is not an exception in this regard. We must stress that parties in any conflict must honor their international humanitarian law obligation and respect human rights. Civilian facilities, school and hospital, humanitarian workers, peacekeepers are not the targets. Attack upon them must stop. Indonesia offers her deepest condolences to the innocent recent victims, including UN personnel all over the world, including recently in Libya. Mr. President, I will make 3 pertinent points today. First, as the first step toward peace, we need to address the root causes of conflict, as Indonesia has always advocated, and we have to continue to build trust. The Geneva Convention are the jus in bello, the laws of war, which must be respected. War is inhuman, but there are codes of conduct. Addressing the root causes of conflict will enable states to achieve greater security. Confidence-building measures should be put in place to enhance the trust between parties and communities. My second point is to save lives. We need to ensure effective implementation and compliance of the IHL. Not only countries should respect IHL, but ensure respect and implementation, as stipulated in various resolutions related to the Geneva Convention. I would like to underline the word ensure respect, which gave meaning for countries to be proactive in ensuring compliances. Through awareness program, training, rules of engagement, as well as others that Peter has referred to. Engagement with all parties is key in addressing conflict. The Council can become a true partner and build trust among all sides in conflict, including through regional organization, which holds local knowledge of what is truly needed to resolve such crises. Existing international rules, including the resolution of the UN Security Council and UN-sanctioned arms embargo, must be obeyed and respected. We call on external actors of conflict to restrain themselves and silence the guns by stopping their flow. Message should be clear to non-state actors and armed groups that they are not beyond the law, including international humanitarian law. Third, we need to strengthen the capacities of concerned states. This includes international partnership to support states in conflict which are unable to provide such protection themselves. Indonesia is continuing its support for conflict and post-conflict states through the South-South and Triangle cooperation. Just last week in Jakarta, Indonesia held a regional conference on humanitarian assistance, providing a platform to share best practices in conducting humanitarian action in Southeast Asia and neighboring countries. And we have also worked with the Red Cross in this regard. That conference once again highlighted the needs for partnership. The IHL is a living document and still and will always be relevant for the future. But noting the world has changed dramatically, we should adapt also to present-day realities. Our approach in bringing the message of compliance and the need for abiding to IHL for all parties should also be adapted. Mr. President, in conclusion, allow me to quote the Indonesian Foreign Minister during our presidency last May open debate on protection of civilians. I quote, "The Security Council need to be reminded not only of our political commitments, but also of our duties to implement those commitments, which is to ensure the primacy of human safety and security. The UN was established upon the mandate of, I quote, we the peoples of the United Nations. We cannot afford to fail and let our people down." I thank you, Mr. President.
I thank the representative of Indonesia for his statement. I now give the floor to the representative of Peru.
Mr. President, we would also like to begin by thanking Poland for having convened this meeting on a priority subject for the international community. And we'd also once again like to welcome you amongst us, Minister. We'd like to also thank the Undersecretary General for Legal Affairs, Mr. Miguel de Cepa Soares, the President of the Committee of the Red Cross, Mr. Peter Maurer, whose organization plays a central role in this area, and Madam Annyssa Bellal from the Geneva Academy of International Humanitarian Law. We thank them for their briefings. We feel that in the increasingly interdependent world in which we live, the validity, development and defense of an international rules-based order is essential and the only way for the international community to effectively counter the serious threats and challenges that it faces on the basis of the purposes and principles enshrined in the United Nations Charter. And this is why Peru is committed to the rule of law, multilateralism, and the principle of the peaceful settlement of disputes. In this regard, we give full priority to complete respect for and compliance with international humanitarian law, because it represents the minimum standard of dignity in situations of armed conflict, and it should be strictly observed by the parties with regard to the protection of civilians, as well as those who are not able to continue in the conflict because they are wounded or detained. The Geneva Conventions of 1949 and its additional protocols, The 70th anniversary, which we are celebrating and commemorating today, constitutes the cornerstone for this protection. The importance and relevance of these conventions has been highlighted by the International Court of Justice, recognizing them as part of jus cogens. These conventions in particular, as well as international humanitarian law in general, represent a fundamental tool for the work of this Council, and they have been highlighted in many resolutions and presidential statements as being essential elements for the promotion and consolidation of international peace and security. Likewise, we are concerned that very often discourse does not meet with reality, such as in Syria, Yemen, and Libya, amongst other conflicts. Likewise, it is particularly important to guarantee the provision of humanitarian assistance through free and unrestricted access for humanitarian agencies and organizations on the ground, whilst at the same time ensuring their proper protection. We also believe that the adequate implementation of international humanitarian law goes beyond the application of its measures of protection and includes the need to strengthen justice and the rule of law and the fight against impunity. This means that we must promote greater trust in legal institutions and that there must be an effective deterrent, particularly vis-à-vis crimes of atrocity, at the same time as ensuring full respect for the decisions of these institutions. From our perspective as a troop-contributing country, we assign the highest importance to the knowledge and application of these laws in the training of our officers. Also, Peru has established a national commission for the study of and implementation of international humanitarian law, with a view to training Peruvian officials in this branch of law and to highlight its importance. Finally, we would stress the urgent need for this Council to remain unified in the need to defend and promote international humanitarian law and the protection of civilians in conflict, particularly in various cases that are part of our agenda and where currently joint and decisive action is required. Only in this way will we be able to meet the indispensable requirement to humanize conflict, which is also part of our primary responsibility to maintain international peace and security. Thank you.
I thank the representative of Peru for his statement. There are no more names inscribed on the list of speakers. The meeting is adjourned.